Copyright law protects most kinds of writing, including original works of fiction, nonfiction, poetry, and contributions to periodicals. It even protects original works on the internet, such as blog entries, online articles, and many social media posts. Copyright law calls works made up of words, numbers, or other verbal or numerical symbols literary works. In this video, we'll discuss what literary works copyright protects, what it means to be a copyright owner, and how you can register your works with the U.S. Copyright Office. To be protectable under copyright law, a literary work must meet a few standards. 1. A human must have independently created the work. If you include written excerpts or images created by another author in your work, you do not own the copyright in those portions. 2. The work must be sufficiently creative. What matters is the degree of creativity, not the literary merit of the work. Individual words, even new words you might create, titles and slogans, are not sufficiently creative to be protected under copyright. The typeface, format, and layout of text on a page also lacks the necessary creativity. Other materials not protected include procedures, methods, and facts. For example, copyright does not protect recipes, as they usually comprise a list of ingredients and procedures. Copyright may protect, however, the creative narrative that accompanies a recipe in a cookbook or an online blog. Copyright also does not protect the common themes or plots found in particular genres. For example, you might expect a Western to include a duel as part of its story, or for a mystery novel to include a crime-solving detective. And 3, the author must have fixed the work in a tangible medium. That is, the author has written, documented, or recorded it in some form. Copyright does not protect ideas. It only protects your fixed creative expression, meaning the actual words you used in the work. So 2 people starting with the same idea can write different stories, and both would be copyright-protected works. Generally, copyright law considers the author of a literary work to be the person or persons who wrote the work, except when it's a work made for hire. In this case, for legal purposes, the individual who wrote the work is not the author. Instead, the author is the employer or commissioning party. Learn more in our Works Made for Hire video. The author of a copyright-protected work is the copyright owner, unless there is a written transfer of ownership. Owners have several exclusive rights allowing them to control how they or others use the work. No one else can use the work in these ways unless they have permission from the owner or their use falls under one of the exceptions and limitations described in the Copyright Act. See our exclusive rights video to learn more. Although not required, registering your literary work with the U.S. Copyright Office offers important benefits, such as creating a public record of your ownership. Timely registration may also give you the ability to seek certain remedies in cases of infringement. Registering your work or receiving a refusal to register is required to bring an infringement claim for a U.S. work. To apply for registration, you need to submit a completed application form, a non-refundable filing fee, and a non-returnable copy or copies of the work, known as a deposit. Depending on the work, you may have a few application options. The standard application allows you to submit 1 work per application and filing fee. Group options allow you to submit multiple works with 1 application and filing fee if you meet certain eligibility requirements. 3 of the more common are the group registration for unpublished works, the group registration for short online literary works, and the group registration for contributions to periodicals. To learn about the criteria for these and other group registration options, visit copyright.gov. And for more on the copyright concepts mentioned here, check out our Learning Engine series.